Today we're going to talk about getting appointed as a personal representative. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. And two pieces of housekeeping. Today we're going to talk about Minnesota law primarily. I'm not licensed in other states. So if you have a question about the law in another state, be sure to talk to an attorney in that other state. Though a lot of the theories that we're going to talk about will translate over to other jurisdictions as well. Secondly, this video is only for educational purposes. I'm not giving legal advice here, so just be aware. All right, let's talk about getting appointed as a personal representative. I guess the first question is, what is a personal representative? This is the person who administers the estate throughout the probate process. They are going to collect the assets, take an inventory, give notices, and eventually distribute out the assets to those people who they belong. In other jurisdictions, you might hear the personal representative be referred to as the administrator or the executor. Those are kind of old-timey terms. Most states these days have adopted, in one sense or the other, the Uniform Probate Code. Under the Uniform Probate Code, this person is called the personal representative. We may refer to him as the PR as well, because it's kind of a mouthful. So, what is required to be a personal representative? In Minnesota, the legal requirements are quite simple. You have to be 18 years or older, and you have to not have been rejected by the court. That's most everyone. Now, in some jurisdictions, they'll have other requirements. One that I've seen in a couple of jurisdictions is that you can't have a felony on your record to be personal representative. That's kind of an interesting one. But in Minnesota, we have it pretty simple. You've just got to be 18 or above and not rejected. So that creates a lot of people that could be personal representative for an estate. How do we narrow it down? Well, by law, we have a priority for people who can be personal representative. It's first person who has a right to be personal representative is that person who's nominated in a will. After that, then there's the spouse who is also a devisee of the estate. Devisee, remember, means someone who is receiving something as part of or from the will. After the spouse who's a devisee, then you can have any other devisee in the estate. After that, you can have the spouse who is not a devisee. After that, you can have any heir. And I believe after that, it goes to creditor. After 45 days, they can open a probate. And after that, you can have any conservator who can open any probate. I think that's after 90 days as well. The exception, however, for married people, for the spouse, is that if the marriage is dissolved or annulled and the will nominates a spouse that while they were married, the spouse was nominated in the will, and after that the marriage was dissolved or annulled. At that point, any spouse that is of a marriage that is no longer in existence, then their nomination in the will, unless the will specifically says so, will be removed. If they get remarried, they get that nomination back. And we're only talking about annulment or divorce here. We're not talking about legal separation. We're not talking about divorces that are not yet completed. So what if you've got multiple qualified personal representatives? Say we've gone down the list and we've come to sibling who are devisees in the will, and there's three of them, Bob, Joe, and Sue, and let's say that when the will didn't nominate anyone to be personal representative. What do? Are they all automatically personal representatives? Not necessarily. Let's say that only, as I said, Bob, Joe, and Sue, I believe. So let's say Bob wants to be the personal representative, but Joe and Sue really don't want to be it. At that point, they will put forth a renunciation of right to be personal representative. And the two that don't want to be personal representative will renunciate their right, and it will fall to the person who is left, who wants to be it. This actually works that if you are nominated in the will to be personal representative and you can't or just don't want to be personal representative, you can renunciate your right as well. You don't even have to have someone to follow it. You can just renunciate your right, and then you won't be personal representative. Let's take the same scenario, but two people want to be personal representative and the third just doesn't want to do it. Well, the third is going to renunciate their right just as before, The other two can be co-personal representatives, meaning that they have equal right to do everything in the estate. This actually raises a question of authority. In some states, co-personal representatives will have equal right to do any action as a personal representative. For instance, any one of the co-personal representatives could open a bank account or could sell real property in the estate. You don't need both doing it. In Minnesota and other jurisdictions, the co-personal representatives must act unanimously, meaning that if they need to sell property, they both need to sign, or if there's more than that, all of them need to sign off on the sale. Now, this inherently creates a danger. What if the co-personal representatives don't agree? We're not in a majority rules. If you have three co-personal representatives, if two want to do something, one doesn't, that doesn't mean the two win. There's still a disagreement and we don't have unanimous action. This can cause a stalemate. In this case, we're going to talk about it in the next video. So we're going to hold off on answering that question and go to the last situation, which is if nobody wants to be personal representative. Let's say there isn't a will and there's no assets in the estate. Maybe there's nobody that's an heir. The person was never married, they don't have any heirs, their parents and their siblings are all dead or can't be gotten a hold of. Then what do you do? Well, remember, a creditor, if there's a lot of debt and there's some assets, a creditor after 45 days can open a probate and be personal representative. But what if there's just no assets at all? What if there's the creditor is owed $1,000, but there's zero assets in the estate? They're just not going to open a probate. So if there's no one that wants to be a personal representative, there just isn't a probate. The result of this is any assets are still tied up. If you have real property in the estate, nobody can take it over. I'm not entirely certain what happens. I would imagine the state would intervene at some point. But without a personal representative, there is no probate that's opened. So now that we've figured out who can be personal representative, let's get that person appointed. For an informal probate, what you do is you put forth an application to be personal representative, and you sign also an oath that says, I agree to be personal representative. It goes to the court registrar, and the registrar makes the decision appointing the personal representative. In a formal probate, you put forth a petition for formal probate and appointment of a personal representative. Again, they'll have to do an oath. There is a hearing in front of a court where anyone that wants to object can object. And after that, the court issues an order appointing the personal representative. Once a personal representative is appointed, either informal or informal, then we have what's called the letters are issued, and the person that is personal representative has authority to commence with the probate. So there you go. That is appointing a personal representative. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. If you have questions, leave them in the comments below. Happy to get to them, or just send me an email. That's not a problem. Some people have already done that. If you like the series that we're doing right now on probate, we probably have another 8 or 10 videos that we're going to be doing. We're releasing one every other Wednesday, so look forward to that. And that's about it. Until next time, this is Gregory Singleton with Signature Law.